So, here we are for the last panel of this not final conference, Scotland conference. I'm not going to take that from Rosanna. My name is Patricia Živković. I wasn't there for dinner last night, so those who do not know me, I am the girl who proclaimed love for Guido yesterday at the General Assembly. No, I will not ask him to marry me today, maybe next year, and I need a ring, but we'll see what's going to happen. And I'm also Rosanna's sidekick. I'm checking my notes because Rosanna told me to be careful what I'm going to say. And for the past half an hour, I was just striking things out. Okay, I can't say this, but I can say that I am Robin to her Batman, and I'm Spider-Man to her Iron Man, and I'm Darth Vader to her Emperor. So, I know, there is a secret message there. But those are two accomplishments that I'm most proud of within Scotland. Everything else you can see online. I do some research as well. But it's not about me. It's about 5 speakers and 4 papers that we will hear about in this last panel. The title or the topic theme of the panel is Research for the Better Future of Data Subjects' Rights. Let's be real, we were all waiting for this. This is basically the cream of this conference. No offense to previous speakers. I have to keep them awake. They just had lunch. I'm trying to entertain you so that we don't lose concentration because these speakers deserve same concentration as the first ones. So who will we have today? We will have Dr. Birgit Schippers from the University of Strathclyde, who will talk about law and data justice, a critical approach towards the regulation of biometric technologies. I am not even going to try to hide that I'm biased. This is the talk that I have been waiting for because biometrics is one of the topics I'm researching on. After that, I will give a short introduction for every speaker as we go through presentations. After that, we will have a paper on data rights and as a research methodology, a systematic literature review, presented by Adamu Habu. This is his first presentation ever in career, so yes, I'll ask for that once again. Let's cheer him up as soon as it's his turn. The paper was, however, co-authored with Dr. Tristan Henderson from the University of St. Andrews. Both of them are researchers there. After that, we will have Dr. Gianluca Andresani. He's our brother from another mother, because what I'm meaning by that, he works at a campus in Qatar. So the University of Aberdeen has a whole program, LLM and undergrad there. And Dr. Andresani is there, one of the program leaders for LLM. He will talk to us about accountability for privacy. And the title of the paper is Through the Looking Glass, Darkly, Accountability for Privacy. So I'm very much excited to hear about that. And last but not least, 2 presenters for the last topic for the paper that was co-authored by 5 people. You don't see that often in legal studies. The title of the paper is Empirical Research on the EU General Data Protection Regulation. And its components, a systematic review, and the presenters will be Zihao Li and Wenkai Li, not related. I've asked, very important. And they will present their other co-authors when their term comes. As far as I know, I think Wenkai, this is your first in-person presentation as well. So let's try to cheer them up when the time comes. Housekeeping rules for the speakers. We will have all 4 presentations first. You each will have 15 minutes to present. I will give you a sign 5 minutes before the end and then 2 minutes. And then, has anyone seen the Oscars this year? Rosanna is rolling her eyes. She can't believe I'm going to do this joke. I'm going to do it. Not only that, I'm going to do the thing. Has anyone seen the Oscars? So you know that they usually have a song to kind of show them off the stage if they're taking too long. This year, the host decided to dance them off. So the speakers, if you see me shimming in your direction, I couldn't have a straight face. That means that you need to finish and that it's time to give the floor to someone else. I'm not joking. You can test me, but it's also going to ruin the point that you're trying to make because everybody will be looking at me. There is no way that anyone will listen to you. Okay, 15 minutes, with the exception of the last paper, because we have 2 presenters, so they will have 20 minutes both together. After that, you can come here and sit all together. Please, everybody, write down your questions, and we will have a discussion and hopefully finish this in good spirit and on time, because I'm scared of Rosanna, basically. That's the main reason. But here we go. So our next topic is data rights as a research methodology, a systematic literature review, presented by Adamu Habu, but supported from the audience by co-author Tristan Henderson. Please join me in a round of applause for Adamu. It's his first presentation, and then I'm going to give you a short biography. You can find your presentation at the same time. So, Adamu is a PhD researcher in the School of Computer Science, University of St. Andrews. He's interested in researching data rights. What a surprise. His research is trying to understand how we can use citizen science to understand impediments in researching with data rights. He already holds 1 master's degree in computer and IT from the University of St. Andrews and a bachelor degree in computer science from the Abu Bakr Tafawa Balewa University, Nigeria, more or less. Okay, I got that right. As I said, the paper is co-authored with Dr. Tristan Henderson, also working at the University of St. Andrews. Would you prefer this microphone or this one? Okay. Please give me some attention every now and then so that I can show you how many minutes you're left.
So, thank you very much. Hello, good afternoon, everybody. My name is Adamu Habu. Unlike some of you, I'm not a lawyer. Unlike my supervisor, who is directly ahead of me, I'm not a fake lawyer. Rather, I'm a PhD student at the School of Computer Science, University of St. Andrews. The talk I'm going to give is about my literature review, which is part of my PhD. So the focus is on academic studies that employ data subject right as a methodology for data collection. So let me start. Sorry, the voice may be shaken. This shows my inexperience. I'm sorry. So data protection regulations afford some rights to data subjects. For example, the GDPR in Chapter 3 delineates some rights, right of access, right to data portability, and what have you, to data subjects. These data rights means different thing to different people. To researchers, it is a tool for research. Thanks to advancement in computer technology today, almost everything in our life is online. We submit the data, which might be personal and sensitive, to online data infrastructures, which are owned by technology businesses. So researchers need to understand some concept about our life. For example, as a researcher, I may decide to find out whether website cookies influence how people shop online, for example, as part of a research. In order to do this, I need to study website activities of data subjects. But how can I get the data? Without data protection regulations, this business might not give me the data I want for some reasons. Maybe their business model, they don't want to compromise it, or a lot of things. So these data protection regulations provide means whereby the researchers will get this data. And this data might be personal, as I made mention, or it might be sensitive. So then the next question is, why the review? The coming into the GDPR has changed a lot of ways companies deal with data, not only in Europe. And I will admit that GDPR is for the European nations. I may be wrong. But research studies shows that coming of the GDPR has changed a lot of things regarding how companies treat data, not only in Europe, but rather globally. So there is need to study this particular chapter 3 to see how it's been responded. Second, researching with data rights, of which I will explain if I proceed, is new. So there is need to study this thing. So that's why our literature review focus on this, to gather the studies so as to identify the gaps and the problems of it. Next, how did we do the literature review? That's the method. First, we try to establish whether if there is an existing literature review about this topic, of which we did not find. So we conclude to do the literature review. By doing so, we use a commonly used set of guidelines by Ketchenham and his colleague from the University of Kelly here in the UK. Our focus, as I made mention at the beginning, is on academic studies that employ data rights as a methodology for data collection. And we use the last 20 years so as to accommodate as much as different data protection regimes. So that's why we use the 20 years. So, and we searched 6 interdisciplinary electronic databases. The reason is that researching with data subject right is interdisciplinary. It's just like a software. A statistician or a psychologist or a lawyer or a medical doctor can use a software to do analysis. Likewise, researching with data rights. So we have to try to accommodate different disciplines. And this is it. So going by the graph, so these are the search databases. So the search, we use 3 phases. In the first phase, we use the string, and our search string covers all data rights. And to be honest, we are so biased. We use the GDPR, but we try to accommodate other strings as well in the rights. So I will explain that in the limitation. So after querying, so we got these papers. So in the second pass, we read the abstract of each of the paper. So those papers that pass, in the last third pass, we read the whole paper, so as to make sure that, yes, they're using this subject right as a methodology for data collection. At the end, we got 32 papers. So these papers we use in our analysis. So what did we find? So first, we found that among some of the findings, the major ones, data subject rights can be used for different purposes. For example, auditing pervasive systems. One of the papers, which was authored by my supervisor, tried to audit pervasive systems, measuring legal compliance, studying human activities among the purposes of the research. But majority of them are trying to measure legal compliance. I'm telling you this is going to be speculative based on what I think. It's not mentioned in the paper, and I have no literature to back what I'm going to say. My reason is, I think the reason why is that the data subject right research is new, so most of the researchers don't know of this. So most of the researchers are trying, they have a legal knowledge, so they're trying to see whether these companies will comply with the provision of the law. So that's why there is high concentration of the legal aspect of it. But as time goes on, researchers will know the value of these things, so maybe there will be shift towards the other aspect. Like my supervisor, so since he knows the advantage of it, he used the right to try to audit pervasive system, which is not part of the legal. The next is that the right of access is the most commonly used data subject right by the researchers. And this can be attributed based on the analysis to 3 factors. One, right of access is the primary driver to implement other rights. If you don't know what the company holds about you, how are you going to rectify it? How are you going to delete it? So one. The second reason is that right of access, as compared to other rights, provide easy monitoring of compliance. Third, existence of studies to compare, one of the study was trying to compare the regime before the GDPR and after the GDPR. So since there is existence of data in literature, so they use the right of access. So next we found that exercising this data rights requires legal and technical knowledge at bare minimum. You need to have a legal knowledge and technical knowledge, and I will explain this further if I go to the challenges, which is in the next 2 slides that will come. Next is that some of the researchers recorded both facilitative and restrictive practices. By this, I mean that if it is facilitative, like the controllers behave in a good manner, complying with the provision of the law, and what have you. If otherwise, then it's restrictive. So both facilitative and restrictive practices were experienced by the researchers. Then next is that we could discover scalability limitation. So this is a CDF, cumulative distribution frequency diagram. So to the y-axis is the probability of the distribution, while to the x-axis is the number of data subject requests. So if you look at it, 75% of the request is below 40. That is the number of data requests sent to the companies. So more than 75% sent less than 40, while the midpoint of the data is 19. So that those that has a higher number of data requests sent to the companies are just like 25%. So this clearly shows research scalability limitation. So this is what my PhD is trying to work on, how to use citizen science as a framework to improve the scalability of this kind of research studies. So I will explain if I have the time towards at the end. So next issue I'm going to discuss is the issue of the challenges. So the challenges regarding this. So based on this analysis, based on our analysis, we look at the studies and try to see what are the challenges. The first is that some of the studies were designed to discourage data controllers. The intention of the drafters of this regulation is not to overburden the data controllers, but rather to ensure transparency. So, but some of the researchers trying to, in their study design, they design longitudinal studies whereby they send multiple unfunded requests to these controllers. So the controllers were not happy, some of them like trying abusive language, which is to some extent. So it's a common knowledge that these controllers spend a lot of fund trying to fulfill this legal obligation. So why should the researchers try to discourage them? So next is that, and it will affect the implementation of the law. Because even if you are sending a legitimate request, based on the experience they have, it might prevent them from fulfilling that request. So another challenge is that data subject studies are hard to conduct. The reason is that you have to recruit these participants, train them, retrain them, and one problem is that interpretation of the law. because some of these controllers are using different interpretation of the law to deny the request. If they don't want to provide the data, they might use different implementation of the law. Sorry to say this, one funny thing about the law is that it's subject to interpretation. A judge might decide in a court of law to say that this is my view. Another dissenting judgment will say this is my view, and you cannot query that. So these are some of the problems. So this kind of research are very hard to conduct. Next problem is that there is widespread lack of education. Both the data controllers as well as the data subjects, they don't know of this regulation. They don't know how to exercise this. So there is limitation of education. Next, how are we going to know that the responses from the data controller are complete? There are some instances whereby the data controllers can still answer the request without providing the data, because according to the law, there is exception. Or let's say in case of CCTV, if it has been deleted. So how is the data subject? Because these laws are written for everybody, not only legal professionals. Everybody can use it. So how are they going to know that, yes, this response is complete or is not complete? Next is that usefulness of response provided. I could remember one of the PhD from Glasgow, when she was presenting, she made mention about the controllers providing chunk of data which might be not useful to the data subject. In one study, the researcher requested for CCTV data and was handed chunk of papers. So if the researcher is interested, for example, is a psychologist who is trying to use machine learning to know the movement of the data subject, how is that going to be helpful? So there is need. Then the researchers acting in the role of data controllers. So this might offend Article 6 of the GDPR. Because of time, I will not spend much time. So the open questions. We identify two main open questions. One is that the majority of these researchers are expert in their field. Tristan and his student in their popular paper, How Portable is Portable? How Portable? I can't remember the title. Tristan is a resource personnel. He holds a master's in law. Janice is having a law degree as well. So majority of them, that's the case. They are expert in the field. Even if they are not expert, they use lawyers and privacy experts to help them. So these laws are written to help everybody, regardless of your background. So what's going to be the case if non-experts are placed in that field? So it's worth studying. Another thing we discovered is that in this whole studies, the researchers are more important about the views of data controllers and the data subject. There are three critical stakeholders as far as this issue is concerned. The data controllers, the data subjects, as well as the DPAs. But nobody cares to hear from the data controllers. So in issue of fair hearing is what? Studying the data controllers as well. So to conclude, we collected and analyzed 32 academic studies that employ data subject right as a methodology for data collection. We found out that the right of access is the most used data subject among the researchers, of which I explained the reason from the papers. We find a variety of difficulties using data subject right for research studies, of which in the discussion and challenges I have pointed out. And researching with data subject right is new. So when things improve, I hope a lot of people will be using this, researchers will be using this data subject right. So for my PhD, I'm trying to improve this study. I want to use a framework called citizen science. What citizen science is, inviting non-scientists to participate in science. So I'm trying to see how I can invite non-scientists. So I'm building the framework at the moment. So I'm trying to see how to invite non-scientists to come and see the possibility of expanding the scale of this kind of research studies. Thank you so much, and I appreciate it. Sorry, this is my email. So if you are interested in any research that has to do with data subject rights, I think I'm the right person. You can shout at me. Thank you.
Thank you so much, and thank you for great time management. That was fantastic. I'll just leave it on until I introduce the next topic and the next presenter. I think, Adamu, you did a fantastic job. I have to say it's really brave to show a graph to a room full of lawyers, because I'm pretty sure we all went like, ooh, pictures, right? What does it mean? We don't know. But fantastic. Thank you so much. And I'm pretty sure that there are many of us who are dealing with data subject rights. So feel free to reach out to us as well if we don't reach out to you first. Thank you. Final presentation of this conference, and today, last but not least, cherry on top on the topic of empirical research on the EU GDPR and its components, a systematic review by Zihao and Wenkai. Now, this will take some time, but I will read it through. Young researchers, but quite impressive biographies. So Zihao is a PhD candidate and research assistant at Create Centre, University of Glasgow. His research topic is data protection in the context of online algorithmic pricing in the EU and China, a comparative analysis. Those who were really attending all the activities of Scotland, you could have listened to his talk, enlightening talk. He's both qualified in computer science and law. Based on his interdisciplinary background, his research interests mainly concentrate on the intersection between information technology and law, including algorithm regulation, data protection law, blockchain and law, internet and IP, and e-evidence forensics. Whew, okay, that's one. Wenkai, joining us for the first time for the conference, is a PhD researcher at the Law, Science, Technology and Society Research Group and the Health and Aging Law Lab of Vrije University of Brussels in Belgium. His research interests include the EU data protection law and data governance policies, with a particular focus on the use of health data, and also the Chinese data protection law and digital policies. Currently, he is also engaged with the EU project Facilitate, funded by the Innovative Medicine Initiative, focusing on legal compliance in developing solutions for the return and secondary use of patients' health data in clinical trials. Wenkai completed his Master of Laws in Advanced Studies in Law and Digital Technologies at Leiden University, the Netherlands. He subsequently worked as a research assistant at the Center for Law and Digital Technologies, E-Law of Leiden Law School. Prior to that, he obtained his Bachelor of Law in China. So you have 20 minutes altogether. 10 minutes each, or however you organized. Would you like to share this microphone, or would you like each to have their own?
Thank you so much. Thank you very much. And finally, it's the two of us who are not related. And hello, everyone. My name is Wenkai, and today I'm co-presenting with Zihao from the University of Glasgow, and from the two of us, this paper is also co-authored with Wenlong from Ali Research, Yueming Zhang from Ghent University, and Aolan from Queen Mary University of London. And we have changed the title a little bit. In this paper, we did a systematic literature review on the empirical studies on the EU data protection law, where we're happy to see there is interesting overlapping with the study of Adamu's. And Just like the title suggests, our starting point is the narrative that we heard a lot throughout the 5 years of GDPR's enforcement, that GDPR is failing, all the doubts that is GDPR really capable of realizing the objective that has been set for it. And this skepticism is not coming from nowhere. We can often heard DPAs are accused of lack of enforcement, and digital industries is complaining that GDPR is killing innovation and competition. And this is also reflected from the recent ongoing UK data protection law reform, where there are proposals to deal with many of the pain points of GDPR. And also from the individual perspective, not many people think GDPR is useful, but rather it just adds to the hassle that they have to make a choice every time they have to open a website. And and our work has been inspired by the American legal scholar Roscoe Pound and his thoughts on the distinction and connection between law in action and law in books. And we do see the value of empirical studies which review or try to review how law in action is. And with all the assumptions and arguments about GDPR, we want to look into how these studies reflect the law in actions. And as far as we know, we haven't found any similar work to put all these materials together. So we want to do this to fill in the gap. And we want to do this also in conjunction with the doctrinal work, and hopefully we can reorient the mainstream narratives in the evaluation of GDPR, and many of the findings and conclusions we will explain it later in this presentation. And also from the perspective of methodology, we also want to reflect the quality and diversity of current empirical research to see what aspects are the most frequently studied, what are missing, or is their methodology or conclusion plausible, and hopefully we can offer some recommendations for the future research. And this is our methodology. I'll skip the details for the sake of saving time. Basically, we use two methods. One is to search for keywords in academic databases. The other one is to use the method of citation chaining, or so-called snowballing, to find additional papers that we think are exceptionally good and from reliable sources. So after evaluating according to our preset criteria, we have identified 125 papers in total. And here's a chart showing topic distribution of the empirical studies. As we can see, the studies examining data subject rights are the highest number, especially rights of access. But some of the elements of GDPR, such as data protection authorities or GDPR fines or CJEU cases, which we think should be important indicators of GDPR enforcement, are less examined. And to organize all the materials we have collected, we developed a conceptual framework to organize the discussion. It consists of a macro perspective and micro perspective. So the rationale behind this is, we think although GDPR is a legal instrument, but it contains a variety of tools and mechanisms, and they are highly heterogeneous. So we don't think it makes sense we only look at GDPR as a whole, but also we need to look at various elements as GDPR's components. I'm going to quickly go through our discussions from these two perspectives. I'm just going to talk about the main takeaways because there's a lot of things to unpack. So from the macro perspective, the first aspect we examined is the public perception and attitudes. For this topic, the methods are mainly questionnaires and interviews with data subjects. Like some studies reported, for example, reduced privacy concerns, and some studies reported increasing willingness of people sharing data, but actually we find very little normative or regulatory reflections. We just see the data, but we don't know how to improve the situation. And also our reflection is that this kind of self-reported data, the validity of this kind of data is contestable. And also it is very difficult to come to a generalized conclusion because these studies used very divergent criteria. They have different sample size, they have different focus groups. So it's very difficult to say in a general way how the situation is. And the next aspect is influence and impact of GDPR. So this kind of study focuses on the impacts of GDPR on a specific sector or realm. For example, the impacts of GDPR on multinational corporations or the impacts on financial services. There are some general patterns we can identify. For example, it adds to the workload of employees in the companies, but also some unexpected consequences. For example, one study reported that in advertising industry, GDPR didn't really work on those unfair commercial practices, but rather it adds to the difficulty of the news or other kinds of legitimate activities. And also same problem with self-reported data and also generalizability. The third aspect is compliance. This actually takes up a great portion of the studies. The main method they use includes analyzing privacy policy and also conducting controlled experiments. This mostly related to the functioning of interfaces or technical design. And also there are some interviews or questionnaires. The reflection we have in this aspect is what is compliance? What is the benchmark or indicator of compliance? These indicators among the studies are not consistent, and that is the problem. So it is also very hard to generalizing. Just bear with me. I have 3 more aspects. And accountability. This notion is connected to compliance, but we define it a little bit differently. So we define accountability as the capability or willingness of data controller to comply with law. So it's more like a subjective perspective, but this is only partially evaluated. So most of the studies focus on the institutional aspects, which means the governance structure of a company or something like that. Some studies conducted interview with DPOs, and some studies fit GDPR requirements into a broader enterprise design and management solutions to see how the company architecture changed because of GDPR. And enforcement, to our surprise, there are only a small number of studies, as you just saw in the topic distribution chart. CGEU cases, GDPR fines, and decisions of DPAs, we think these are direct indicators of GDPR enforcement, but there are only very few papers which examine these aspects, which we think is not sufficient. And the last aspect is effects on competition and innovation. Although competition is not dealing with issues of competition is not the direct objective of GDPR, but there are actually a lot of studies which touched upon on this topic, and it also echoes with the debates I just mentioned about whether there are negative impacts of GDPR on the digital industry. So I think in these aspects, there are mainly 4 takeaways. So some studies reported declined business performance, for example, declined number of views on the website. And another direct result of GDPR's enforcement is concentration of markets, and also difficulties in data synergies, and also from the small and medium enterprises perspective, they are put in the disadvantaged positions in terms of the implementation of GDPR. That's it for the macro perspective, and then I'll hand it over to Zihao for the next half of the presentation.
Okay, thank you, Wenkai. So I will now take over for the macro perspective. So for the macro perspective, we firstly look at the transparency and the privacy policy. So we noticed that there are a lot of empirical work examine the privacy policy, especially focused on some specific sectors. For example, the mental health app, the public sector website, and also the vulnerability of specific groups like the children and the elderly and the disabled person. However, the term readability of such privacy policy is not clearly defined. And another part in this area is the automatic tools that can generate the privacy policy. We found that there is a clearly empirical evidence shows those automatic generated privacy policy is often incomplete and inadequate, which often lead to the excessive collection and processing of the personal data. So the second part is the consent. We found that a lot of research tend to detect the new changes by the GDPR. So to conclude, you can see the overall status of the consent obtained has been improved with the coercive placing of the cookies significantly reduced. However, this does not suggest the GDPR's success because firstly, only 4% third-party tracking app in Android has established the sufficient lawful basis. And there is a clear evidence shows the advertising industry is significantly affected, but the individual are still not able to check by themselves whether the data controller follows their preference or if they process their personal data unlawfully. So this leads to a lose-lose situation. On the one hand, the industry is significantly affected, but on the other hand, the individual still cannot fully control over their personal data. Okay, so the third part is the dark pattern. We notice that the empirical evidence shows actually the dark pattern is not something that only the data protection law can solve it. but it required a coordinated effort. So not only data protection law, but also the consumer protection and e-commerce. And so the next part is the design. Because the GDPR introduced the privacy by design and by default, so we noticed that some empirical evidence look at this issue from the engineering and the software developer perspective, with very little focus on the legal perspective. So they mainly investigate the privacy by design, its implementation in the practice. And due to the privacy by design's elusive nature, this kind of empirical research mainly identify if there is any pre-existing solutions. And then this is the part about the data subject rights, so which is more or less a little bit overlap with Adam's research. But we look at it from the whether the data subject rights can effectively protect the individual. So you can see, firstly, many empirical evidence shows that there is a huge gap between the increased public awareness of GDPR rights and their low usage rate. Also, there is evidence shows many tools may cause hurdles and challenges, especially from the transparency to consent and to the data rights. They are not necessarily function well as they intended. So from the methodological perspective, so the actual effectiveness of such rights is not thoroughly examined, as a great portion of the work actually focus on the awareness of such data rights rather than their effectiveness. And also, lastly, most of the data subject rights seem to be used exclusively by the data protection experts, just as Adam mentioned. So many researchers use the data rights to do their research, but we should be aware that those data protection rights are not designed for the researcher, but for the individual to protect the data subject. So due to the time limitation, I will not go through the individual rights. So to conclude, there were actually 4 takeaways. So firstly, for our research, we noticed that instead of focusing on the failure or the success help of the GDPR, when we try to evaluate the GDPR, it would be better to frame it within the effectiveness framework rather than say the GDPR is successful or failed. And then when we evaluate the GDPR, it is very essential to look at it from the macro perspective. So that means we need to consider the performance and the implementation of different GDPR components. And thirdly is the current empirical research is significantly determined by the availability of the GDPR-related data. So if there is data that is quite hard or does not exist, for example, for the Article 22 of the GDPR, we notice that only one paper look at this issue, but it is very important because we use this right to not to be subjected to the automatic decision making. And finally, when we evaluate the GDPR, it is important to acknowledge that there is a distinct objectives of the GDPR compared to the other laws, for example, the consumer protection and also the competition laws. So that's it. Thank you very much.
Perfect.